This fall, the U.S. Supreme Court will take up a case that could overturn its own ruling legalizing same-sex marriage.
You may recall that Kim Davis is the Kentucky clerk who was jailed for 6 days in 2015. She refused to issue a gay couple a marriage license on religious grounds. Davis is appealing that verdict. She says it was, quote, egregiously wrong that the High Court extended marriage rights for same-sex couples under the 14th Amendment's due process protections.
Jessica Levinson is a law professor at Loyola Law School in Los Angeles and is an expert on constitutional law. She joins us now live to discuss this case and its possible ramifications. Jessica, thank you. First, let's start off with Davis's argument in this case that the 14th Amendment's due process protections don't apply to same-sex marriage. So what is the basis of that argument?
Yeah, it's a great question. So the argument is basically when you look at the due process clause in the 14th Amendment, it protects liberty. And in constitutional law, we have this whole area called substantive due process. And what that really means is basically we're deciding what unwritten rights are protected under the word liberty, meaning they're protected in the Constitution, even though they're not written down. And for instance, previously, we found that the right to obtain an abortion was protected under the word liberty. Ever since Roe v. Wade was overturned, we no longer view that as being protected under the word liberty. And so when it comes to this part of the argument, it essentially boils down to whether or not the right to marry is fundamental, or maybe phrased a different way, the right to marry the partner of your choosing is fundamental, such that it's protected under that word liberty in the due process clause.
So, Jessica, the census says that there are more than 700,000 same-sex households in the United States. So if this ruling is overturned, where does it leave them?
So I want to be clear that I don't think this ruling will be overturned. I think this is a long shot. This is just my opinion. I don't think the court will take this opportunity to overturn Obergefell. Obergefell, which is the decision that said that same-sex couples have a right to marry, is only 10 years old. This is a more conservative court, but I don't think that they want to take this case and overturn recent precedent. If they were to, though, what would that mean? It wouldn't look back on couples who are already married. It would only look forward and essentially allow this decision to be made state by state. I think it's also worth mentioning when we're talking about the Obergefell decision that there's basically two pillars. One we just talked about, the due process clause, but the other is another part of the equal protection clause, another part of the 14th Amendment, the equal protection clause. And that's also part of the Obergefell decision, essentially saying you can't discriminate against people because they want to marry a partner of the same sex.
And looking a little more broadly, too, at this argument, could this be applied to interracial marriage?
So I don't think that we're going to go there, but certainly the argument would be that if you can take away the right to marry because you are of the same sex, because you want to marry a partner of the same sex, then what would be next? And again, I think people who would argue in favor of upholding Obergefell would say, if you're going to take this step, then what's to prevent the next court from saying, well, we can ban interracial marriage? I think there are responses to that question, but I think that is one of the questions that follows this larger conversation about that Obergefell decision.
It is a big case. Thank you so much, Jessica Levinson, for your insight, and we'll see what the U.S. Supreme Court decides. Thank you.
Thank you.